Today we are going to be talking about avoiding foreclosure headaches. What will you need to make a loan? What are some critical documents, an example of a foreclosure, and best practices? Hello, my name is Edwin Epperson. I'm with The Sophisticated Investor, and we are teaching you, investors, how to build, protect, and preserve your family's generational wealth through private lending. So what are some topics of learning that we will be covering today? We will be covering some of the questions that you need to ask whether you're going to make a loan. We're also going to cover some of the critical documents and what information in those documents you need to be aware of. As well, we're going to cover an example of what happens in a foreclosure, as well as best practices for you as a private lender. So first off, will you make a loan? Well, one of the first questions you want to ask is the loan request a safe LTV or loan to value for you? This is all based upon your policies, procedures, and underwriting guidelines. As a private lender, you need to have these. This should be a documented information for you to refer on every single loan. So is the loan request a safe loan to value for you as a private lender? For every lender, it's going to be different. Some lenders are fine going up as high as 90% or even 100% loan to value. Other investors are very risk averse and they want no more than 50% loan to value. Regardless of the scenario, understand what your loan to value requirements are, and then always stay below your loan requirements, your loan to value requirements. Second question, has the borrower provided complete and accurate documents? This is extremely important, especially if you have never done a loan before. You're going to be doing your first loan. You need to know what complete and accurate documents actually look like. Ask me how I know. Within the first couple of loans, I had a borrower that submitted to me documentation that I didn't really know what I was looking for, or more importantly, I didn't know what I didn't know. I didn't know what fake documents look like, and he submitted fraudulent documents. And so this is a hard lesson learned for me, and it's one that can be avoided as long as you know what documents to look for. The second question is, does the borrower have enough skin in the game? This is a euphemism in the industry for down payment. Does the borrower have something to risk? Meaning, if the borrower defaults and they don't continue to pay you your monthly payments, do they have something more than just the projected profit on a property at risk? It's always great if a borrower says, I'm going to make $50,000. I would never default on a loan. That's $50,000 I don't have. However, if push comes to shove and the rubber meets the road, the borrower is in a tight position. They don't care about the future profits because they're in a situation right now to where they're not going to be able to even realize those future profits. So if they don't have something at risk, it's much easier for them to walk away from a deal and leaving you high and dry. So always make sure the borrower has some skin in the game. Another question, does the borrower have a valid entry and exit plan? Meaning, is the plan how the borrower is going to buy the property, what they're going to do to the property, and is the exit plan a realistic exit plan? One of the biggest exit plans that probably falls apart are the type of real estate investors that buy a property to fix it up, put a tenant in it, and then they want to refinance. However, if the borrower cannot qualify for a loan today, the likelihood that they're going to qualify for a loan in 3 to 4 months is very rare, very unlikely. So just be aware that this is something that you need to look at. If the borrower cannot qualify for the loan today, you have to be willing and okay with floating that loan for an extended period of time until the borrower can. Does the borrower have sufficient reserves? This is much more than just a down payment. You as the lender need to be assured that the borrower will be able to pay all the required fees for owning property, such as insurance, taxes, utilities, and your holding costs for the loan. If they don't have those in reserve, then the likelihood that they come across financial hardships and are not able to make your payments will significantly increase. So always make sure to look at the borrower's cash reserves and make sure that they have sufficient. Will the title be clean, and will you be recorded in the position that you are expecting? This is a very easy way to answer this question. Always go through a title company. Always go through a title company. Never conduct a closing, never wire the borrower funds directly, always go through a title company. And when you do, always require the lender's title insurance. This is the best thing that you can do that will protect yourself against unforeseen liens on the property. Does this return meet your projections? So does the loan meet your projections? Let's say that you're trying to earn 7% annual on your money. Right now, it's all passive. You're simply expecting paychecks every month, and that is to sustain your way of life. However, if this loan request from the borrower is only 6%, then that will not meet your needs. So just be sure that the type of loan that you've structured is also in line with your projections. This goes hand in hand with, does the loan fit within your portfolio needs as well? If the loan is a short-term loan and your strategy is a long-term cash flow, then this loan may not actually fit within your portfolio needs. And the same goes vice versa. If you're really wanting a higher velocity of capital, what we call in the industry, then you're going to want to have much more short-term loans compared to long-term loans. So just be aware of what your portfolio needs are, and does this loan meet within your portfolio needs? The next thing that we're going to cover is critical documentation. Now, critical documentation, there are 6 critical documents, and we're going to go over each one of these and some high-level information that you want to make sure is inside each one of these documents. So first off is the driver's license. Yes, this is my driver's license from way back when. You will notice that in the driver's license, there's obviously your date of birth and some other information. However, what's even more important is the address. You want to make sure that the driver's license has a valid residential address. Whether they're renting, whether they own, it does not matter. Make sure that their driver's license has a valid address. Also, you will get from the borrower a purchase and sell agreement if they are buying a property. If they own the property and they're looking at a refinance, they should be providing you, the private lender, a mortgage, an existing mortgage, or the deed if it's owned free and clear. Either way, make sure that you receive those documentation and make sure that their information on the deed or the mortgage as it stands is actually what is them. It's not a fraud, and it's not somebody else. As far as the purchase and sell agreement, one of the key things that you're going to want to make sure on the purchase and sell agreement is that both the buyer and the seller have executed this document. If the borrower sends you this and they are the only ones that have signed an initial, that's nothing. It's completely a non-legal document. There is no agreement for the seller to sell that property. So just be aware that the seller needs to be signed and listed. Also, you can check the county records to make sure that the listed owner of the property is the one on the purchase and sell agreement. If there's not, if it's somebody different, or maybe even a company, more than likely there could be a wholesaler involved. So as the lender, you have the rights to see if there is a wholesaler involved, the original document between the wholesaler and the seller. Okay, so those are critical documents you'll want to look for. The next is a package of 4 documents. Yes, it's called the CLAP. No, it doesn't mean that. It actually stands for the credit report, the loan application, the appraisal, and the prelim title report. So the CLAP package is something that you absolutely must see as a private lender. And this goes to show all the information about the borrower. So obviously the credit report is going to show you their credit history, which is really what you're interested in as a private lender. Regardless of whether the score is 500 today or whether it's 800, as a private lender, your primary focus should be, are they able to pay their bills today? Because if they can't pay a credit card that's only $50 a month, the likelihood that they're going to be able to pay you, a private lender, for their $75,000 fix and flip loan, it's pretty unlikely. And even if they can financially pay you, the fact that they've shown a track record of not paying their past creditors, it should be problematic for you. So always request a credit report. If you're not a licensed lender, you may not have access to credit pooling software, but you can have the borrower go and purchase a MyFICO Score 3B report. This is an easy report. The borrower pays for it, and yet it'll give you all the information and all current statuses on all of their information. And then you will be able to see if they're paying that. I highly recommend that you go and purchase one for yourself so that you know what a real MyFICO 3B report looks like. The second document is the loan application. Now you can use a standard 1003, or you can use your own personal one that you create. It's really up to you. Just know that if you're going to hypothecate your note, or you're going to sell your note to institutional investors, or maybe to somebody that's doing this more along the lines of a business instead of a passive investment, they may require certain information in the loan application. And if you create your own loan application, you may miss out on that information. I highly recommend you just simply use a 1003, or if you're working with a broker or a private lender that's experienced in the industry, you can use theirs, and their loan application will collect that proper documentation. In the loan application, one of the critical components, again, going back to the driver's license, make sure that that physical address where the borrower resides is correct. It's synced. It's succinct all the way through all the documentation. The third document in the CLAP is the appraisal. Very important. This is pretty much the litmus test of whether you're going to do the loan or not, based on your loan to values. So just know that the appraisal is going to give you a value. You should have a as-is comparable value of what's going on in the neighborhood, as well as a future after repair value. So most appraisers will be able to give that for you. And then you're basically using this appraisal to determine whether you're going to do the loan or not. But it is extremely critical that you have an appraisal or some type of verified, validated, full property valuation. The fourth document and last document is the prelim title report. Now, the prelim title report, again, is extremely critical because it lays out for you as the lender all the issues on title. And at the end of the day, when everything's signed, everything's done, and escrow closes, will you be in the position that you want to be and you expect to be? So the prelim title report, or otherwise called a title commitment, is from the title company telling you, the lender, this is all the issues on title, and this is what we promise, what you will be insured in being on title. So once you have all four of those documents, you have the actual CLAP. So you have that package, and those are the 6 primary documents that you need to look at for any loan. Now, for different types of loans, there's going to be additional documentation. We're not going to cover that today, but just know that in every single loan, these will be the documents that you should be requesting. Now let's go over an example. So in this example, we've got a borrower. They've got an asset. They've got this collateral, this real estate, and they're looking to pledge that collateral for $250,000 at 8% interest only for 5 years. Now, being wise and sophisticated private lenders, if the property is worth $250,000, you're not going to do a loan for $250,000, right? So let's assume that the property is worth $500,000, and this is a 50% loan to value. That's a great loan to value. That would be a loan that most people would jump on, especially at 8% interest only for 5 years. Now, the balloon simply means that this is an interest only. They're only paying the interest for every month for 5 years. And then at the end of those 5 years, the entire principal is then due and payable. Okay, so the borrower either has to sell the property or they have to get it refinanced. Okay, so that's the loan scenario that we have. You come along, you take a look at all those 6 documents, you do some research, some due diligence, you process that request through your underwriting guidelines, and you determine this is a great loan. So you go ahead and give that $250,000 to your borrower, and they offer up the collateral, and they give you a promissory note, and you have a mortgage securing that promissory note to the piece of real property. The borrower is now paying you per month $1,667.67. This is interest only, remember. Now, if all of a sudden the borrower stops paying, you now have to go through foreclosure. So that means you contact your attorney. Now, there are 2 different types of attorneys. There's a real estate attorney, which will more than likely be owner of a title company. You can get any real estate attorney to draft your loan documentation. I highly recommend that you do not use the real estate attorney that your borrower uses. Have your own real estate attorney, and that attorney drafts the documents on your behalf. Okay. The second type of attorney that you will want as a private lender is called a litigation attorney or a creditor's attorney. Now, most real estate attorneys can represent you as a creditor in a foreclosure. However, most real estate attorneys, if they deal in the foreclosure space, normally they are representing the borrower. Okay. So there's a whole business of real estate attorneys representing the borrowers in a foreclosure. A creditor's attorney is specific in the fact that they only represent lenders or creditors, and they have a very unique skill set, and they just approach the whole foreclosure process strictly from your perspective. So it is my recommendation that you actually have two sets of attorneys on call. One is there to always draft your legal documentation for the loans, and the other is there in case you have to foreclose. So you contact your attorney. Your attorney begins the foreclosure process whenever he is able to, or she, and then they will send what is called a breach letter or a notice of default. Now, what does that look like? Where does that go? And this is something that I see all the time, and I want to point out to you as private lenders so that you really, really understand the power of what you have as being the bank or being the lender. So this is a standard mortgage. This is a balloon mortgage. I've blacked out or I've marked out all the sensitive information, but I do want to point out something, and I see this all the time, okay? So in my opinion, this mortgage was probably drafted either one by the borrower on behalf of the lender, or it was drafted by the borrower's attorney, which of course is working for the borrower. As the lender, it is imperative that you do not use the borrower's loan documentation, nor do you use the borrower's real estate attorney. Find your own attorney, and guess who pays for him? The borrower does. There is no reason for you to put yourself at risk like this individual did in making this loan, and I want to walk you through why. So you can see the mortgage was dated May 21st, 2020, this year, if you're watching in 2020. It was made to an LLC, and this LLC is in the state of Florida. And then if you look right here, whose post office address, P.O. Box, and then it's got the number, and it's in St. Petersburg, Florida. Hereinafter called the mortgagor to, and then it would have the lender's information. Now, the problem with a foreclosure, let's say that the borrower in our example is this individual, this LLC. Well, when you contact your real estate attorney to file the notice of default or the breach of contract, and they have to, by law, they have to deliver, because this is a lawsuit, they have to deliver in the hands of the borrower. That means they physically have to be there. If your borrower has a P.O. box listed, there is no one there that can receive that legal document. Therefore, you now have to find a skip trace professional. You have to find out where that borrower exactly resides, and then you have to hunt them down and get them to sign. That's why it is extremely critical that you actually have the borrower's physical address, whether it is in the mortgage or in the personal guarantee. More than likely, if there's a personal guarantee, that will be the case, but even in the mortgage, because you never know if you lose your documentation in a fire, maybe you keep your note and guarantee somewhere unsafe, it gets destroyed or something happens to it, water damage. You need the borrower's physical address in a publicly recorded document. And the best way to do that is in the mortgage or the deed of trust. Remember, you are the lender. You make the rules. If you have a borrower saying, oh, no, I don't like my personal residence listed, tough luck. You're the lender. You get to make the rules. If the borrower wants to borrow your capital, they have to jump through your hoops that you set up. Again, one of the most powerful things about being the lender is that ability to dictate what the borrower is and does not have to do, okay? So that's something I definitely wanted to make sure. I see this all the time. I can go on any county in the state of Florida and find dozens and dozens of these private mortgages drafted by private investors such as yourself, who are probably using the borrower's loan documentation, or they're using the borrower's real estate attorney to draft up the loan documentation. These things are critical. So as a private lender, be sophisticated, know what you should be requesting and looking at. So here's some of the best practices to mitigate the risk of foreclosure. Number one, create underwriting guidelines. This actually should be a formalized document that walks through you and anyone else as you grow, if you decide to turn this into a business, how to actually make loans that keep yourself safe. Also, cross-check the address on the driver's license, the loan application, the credit reports, and the entity documentation. Very critical, again, because of that primary clause or in the mortgagee clause on the mortgage. Because of that fact alone, it is incredibly important that you have the borrower's physical address to where you can send a servicer or a server to their place of residence and get them to accept notice of default if required by your attorney. Also, do Google search. Google is tremendous. You will find a ton of information on people on Google. Do a background check. You can, if you're working with the broker will be able to do a background check. You can also pay for a background check. Actually, your borrower can pay for the background check and then provide that to you. Also, request a proof of mortgage, rent, or utilities reflecting the address. Let's say the driver's license is different than the loan application address, and on the credit report, they've got 1,000,001 different addresses. And in the entity documentation, it's all a corporate address or maybe the address of their attorney. So the best thing you can then do now is ask for proof of rent or mortgage if they own another property they're living in, and even utilities reflecting the actual address that they live at. Also, never, never, never use your borrower's documentation or the borrower's attorney. Always use your own. And if the borrower is saying, well, I don't want to use your attorney because it's going to cost me more money, that's part of the game. Private lenders, you are sophisticated. You never put yourself at risk than you absolutely have to. And this is one of those cases to where the borrower, it is customary for the borrower to pay for your attorney to draft up documentation. Never use the borrower's documentation. Also, remember, you are the lender. You control the risk, not your borrower. You make the rules. If you're requesting something and the borrower says, no, that's not the way I do business, my recommendation to you from past experience, ask me how I know, is to simply let the borrower know that maybe you're not a good fit for them because you require this. And if the borrower is not going to adhere to those requirements, it is best in your behalf to pass on that loan. You do not want to make a loan to where it is a loan that you regret making. This has been Avoiding Foreclosure Headaches by Edwin Epperson with The Sophisticated Investor. Thank you very much for your time. If you have any other topics of conversation that you'd like me to go over, please reach out and connect. I am more than happy to create a presentation, a Learn Lending presentation for that topic. And let's stay in touch. If you haven't found us on Facebook, you can find us at The Sophisticated Investors. I wish you the best in all of your ventures as you build, protect, and preserve your family's generational wealth. God bless and make it a great rest of your week.